Hi, in this episode, we will learn the concept of deposits under the Companies Act 2013. Now, generally, deposits should have ideally been discussed in the context of banks or finance institutions because we know that banks accept deposits from the public and they are repayable on demand. That is, as and when you need, you simply go to an ATM, withdraw the money, right? So that's what is the concept of a deposit. But how does that fit in the context of a corporate law, that too particularly the Companies Act 2013? Let's learn that in our video. Firstly, let's understand the definition of deposits as defined under the Companies Act 2013. The term deposit is defined under Section 2, subsection 31 of the Companies Act 2013 to include any receipt of money either by way of a deposit, loan or in any other form, but it does not include such categories of amounts as may be prescribed by the central government, right? Now let's look into such amounts which do not fit within the ambit of deposit. The idea is that those amounts which are excluded shall not require any compliances which are otherwise required for the purposes of acceptance of deposits. But if the category of such receipt of money does not fall within any of such exclusions, then it shall be deemed to be a deposit, and all the compliance requirements which are required for acceptance of deposits under Section 73 or Section 76 shall be complied with by the company before accepting such amount as a deposit. Now let's learn what are such categories of amounts which are excluded by the government. The central government had provided a long list and we tried to summarize it in our video. So this list includes the amounts which are raised by issuance of secured or convertible debentures or bonds. These are not deposits. Amounts received from an employee with not exceeding their annual salaries. Non-interest bearing amounts which are held in trust, amounts received in the ordinary course of business of the company like that of advances towards supply of services, amount accepted by a nidhi company, amounts received from central or state or foreign governments shall not be treated as deposits, loans from any banks or financial institutions which are provided by such banks or financial institutions by virtue of the documentation required between them. So that will not be considered as a deposit, and thereby the compliance requirements required for acceptance of deposits need not be complied when you are obtaining any loan from a bank or financial institution. Any amount received against commercial paper. So commercial paper is a kind of an instrument provided by banks wherein a loan is rendered at a discount value while it is repaid at face value. So such commercial papers, amount received against such commercial papers shall not be considered as deposits. Amounts received from any other company cannot be considered as a deposit. Amount received and held pursuant to any offer of securities, if it be it for a offer of private equity, a private placement, or any such offer of securities shall not be considered as a deposit. Any amount received from directors per se will not be considered as deposits. However, such directors shall give a declaration to the effect that these amounts are not from their borrowed funds. It's very important that it has to be from their own funds. Further, amounts received by way of subscription in respect of a chit under the Chit Fund Act. So any amounts which is received as a chit shall not be considered as a deposit. Any amount received in a collective investment scheme. See, collective investment schemes are separately regulated by SEBI. So such amounts shall not be considered as deposit because they're already being regulated by SEBI through a different mechanism. Then any amount more than 25 lakh, equal to or more than 25 lakh received by a startup in the form of a convertible note, which means it ultimately gets converted into equity, right? So such amounts are not to be considered as deposits. And any amounts received from alternate investment funds or domestic venture capitalists or infrastructure investment trusts or real estate investment trusts or mutual funds registered with SEBI. So these are all certain regulated intermediaries registered with the SEBI. So any amount received from them shall not be considered as a deposit. So for all these exclusion lists, none of the compliances required under Section 73 or 76 will become applicable because these are all not deposits. However, where a receipt of money by a company does not fall under any of these exclusions, such an amount shall be deemed to be a deposit and the compliances required under 73 or 76 shall be complied with. Deposits may be accepted either from members or from the public. However, the general rule is that deposits from the public are prohibited. But we'll look into how such deposits can be accepted from the public. Now under section 73, deposits may be accepted from the members of the company. And the procedure for that is that firstly, a board resolution is required to be passed, followed by an ordinary resolution. And upon an ordinary resolution being passed by the company in its shareholders meeting, we will go for issuance of circular in form DPT 1. And this circular shall be published in a newspaper. As and when such circular is being issued, the same shall be filed with the ROC in form DPT 1. And only after this, the deposits may be accepted from the members. Now let's look into the requirement of acceptance of deposits from the public. As I said, the general rule is that deposits from public are prohibited except when raised by eligible companies. Now let's understand what are such eligible companies. Now an eligible company means a public company which has a net worth of minimum of 100 crores or turnover of minimum of 500 crores. So private limited companies cannot raise any deposits from the public. And those public companies which have net worth of either 100 crores or turnover of minimum of 500 crores, only they can accept deposits from the public. In addition to that, the company shall also obtain the consent of the members by way of a special resolution, and such resolution shall be filed with the ROC before making any invitation to the public for acceptance of deposits. However, where such borrowings are within the limits prescribed under the Act, in such a case, there is no requirement of a special resolution, and ordinary resolution is also sufficient. In a subsequent videos, we'll explain what is this concept of borrowing power. Now that we understand that deposits may be either accepted from members under section 73 or from public only by public companies having a required threshold, let's now understand a general prohibition for the purposes of deposits. The general prohibition is that deposits repayable on demand are prohibited. So no company can issue deposits which are repayable on demand. Hope you enjoyed our video. Before I end this episode, let me introduce you the concept of deposit trustee. Whenever secure deposits are being proposed to be issued, a deposit trustee shall be appointed, and the timing of such appointment shall be at least 7 days before you issue the circular in DPT 1. Which means even before you go and invite the deposits from the public, you're supposed to have a deposit trustee in place, right? So with this, let's close the episode. Thank you so much for watching. Please do not forget to subscribe to our channel Virtualaw. Thank you.